All right. Well, good morning, everyone, and happy Tuesday on this rainy, snowy day, wherever you may be. My name is Rita Minus, and I'm the program manager with the Pikes Peak Small Business Development Center. I'd like to welcome you all today to Sole Proprietorship LLC or Corporation, choosing an appropriate legal entity. Again, we're glad to have you and look forward to today's presentation. Very quickly, I like to introduce you to the Pikes Peak Small Business Development Center. Perhaps some of you are new and never attended a workshop or have used our consulting services. So very quickly, our center, along with 1,000 other SBDC centers nationwide, offer free consulting, practical training, and business resources to small businesses. With the help from the Small Business Administration, our local corporate sponsors include El Paso County, Ant Business Banking, City of Colorado Springs, Park State Bank and Trust, Lumen, formerly known as CenturyLink, Vector Bank, Colorado Springs Utilities, and as I mentioned, the Small Business Administration. In 2020, the Pikes Peak SBDC was awarded the Region A SBA Innovation and Excellence Award, placing our office top 10 in the nation. Today's webinar is being recorded, and you will receive the recording and the presentation following the webinar today. And if you are interested in meeting with one-on-one with an SBDC consultant or attending other webinars, please visit our website at pikespeaksbdc.org to get started. Next, I would like to introduce DeAndre Johnson with Ent Business Banking. Ent is a great partner of ours, and we couldn't have webinars such as this one without partners and sponsors throughout the community. So thank you, DeAndre, for joining us today, and I'm going to hand it over to you. Say a few words.
Thank you, Rita. Good morning, everyone. Thank you guys for joining today. You are on a task that many people are afraid to do. So definitely get your utensils out to write and pen and paper and everything, because there's going to be a lot of information. For it, we are happy to be one of the sponsors of the SBDC. And if you don't know, we are the largest credit union in Colorado, and we are growing. So it's a great time for anyone who's thinking about starting a business and opening up a business account to come into Ant and see what we have to offer. I will end it there. If you all are interested, shoot me an email, give me a call, and I can send you a promotion that we're running too. So.
Great. Thank you, DeAndre. And if you want to put your contact information in the chat box for everyone, they will have your information. That'd be great. Okay. Next, I would like to go ahead and introduce our facilitator today, Stephen Ogle with Sparks Wilson. Steve's practice areas are business law, estate planning, and probate and tax. He advises family businesses and startups at every stage, from formation and securities offerings to exits and succession planning. His work with nonprofits extend from formation and obtaining federal tax exempt status to advising operational public charities and private foundations. I'll let Steve say a little bit more about himself and get started with today's presentation. Again, we are recording, so if you can keep mute throughout the webinar, there may be times where we go ahead and ask for questions, so you can either unmute or put in the chat box. We will be monitoring that throughout the webinar today as well. Again, thank you all for being here, and I'm going to hand it over to Steve, and I'll stop sharing so you can share your screen. And we'll start with today's presentation. Thank you, everyone.
Good morning, everybody, and almost afternoon. Can everybody see my screen okay now? Great. Thank you, Rita, for that. Yeah, as she said, my name is Steve. Number one thing about me is that I hate talking about myself. So I won't say too much on that. I've been doing these presentations for a while now, and with everything that's been going on in the last year, they've kind of, fallen by the wayside, unfortunately, but I'm really excited to get to do this today. So hopefully I'm not too rusty, and if I am, then definitely let me know. Feel free to ask any questions or anything like that, both while we're going on through this and then also at the end. My main goal with all of this is so that you guys can get a sense of what your options are in terms of selecting an entity, and also understanding why you're choosing what you are. For most of you who are choosing an entity, I could probably tell you right now what might be the best one, but I think it's a good idea to have that background understanding of the benefits and some of the downsides for each of them. So since I'm an attorney, I start with the disclaimer, and everything that I'm talking about today is a pretty limited overview. And so we're just covering the basics, and the specific circumstances that you guys are dealing with will definitely impact some of the decisions that you're making. None of this stuff is one size fits all, even though there are some general concepts that are pretty overarching. The other thing to keep in mind is that the laws change. This isn't as much of a concern when we're talking about the different forms of entity that we're going to be covering, but especially for the tax laws, just keep in mind they're always in flux. And so we're seeing that right now at the federal level. We went through it back in 2017, and it's just going to keep on happening. And so I think the best way for you to keep abreast of that just on an ongoing basis is that there are some websites that really cater to small businesses and provide information for you guys. And if you can subscribe to like the mailing list that they offer, then they're going to give you tax information that's going to be relevant to you. And they're going to do it at a level that's going to be better than what you read like in a news article in the Gazette or something like that. But it's not going to be as wonky as if you're talking to me or a CPA or something like that. So I think that it's a really good starting place just to be aware of what's going on. So when we're talking about the different forms of entities, we're dealing with different structures that are created by state law and then that are governed by the agreements that are entered into by all of the owners. And so from least complicated to most, we're starting with a sole proprietorship, which is not an entity at all. It's just a person who's operating a business without any sort of entity that separates the business from themselves. We're talking about partnerships, which really aren't used much anymore outside of estate planning, and LLCs and corporations. And so most of our focus today is going to be on those LLCs and corporations, and also on the different tax structures and implications that are associated with those. So starting with the simplest, the sole proprietorship. So if you go out and you just start a business on your own, you start selling food, say out of your house, you're making it in your kitchen and you're just selling it to people that you know. You've started a business, but you haven't done anything like filing with the Secretary of State or entering into an operating agreement or anything like that. And so that is the essence of what a sole proprietorship is. And the good thing about it is the ease with which it operates, because there really is no difference from you. So you don't have to worry about different accounts or anything like that. This makes sense when you're dealing with business that is very simple, low risk, and probably not something that you're too heavily involved in. So the example that I have there is selling dolls on eBay, right? So it's probably something you're engaged in on the side of your main source of income. Selling dolls, you know, it's not going to be too high risk as far as I can tell. And so if you're doing that through your own name as a sole proprietor, probably not too much risk that something is going to go wrong and you're going to be faced with a liability. On the other hand, if you're building homes, you're probably doing that as a full-time occupation. And there are a lot of risks and liabilities associated with that. So if you got sideways with a subcontractor, or if something that you built had an issue, then those are areas where you might have some liability. And so it might not make sense to be set up as a sole proprietor at that point. So when you're evaluating whether or not you really need that liability protection, the key is evaluating those risk tolerance factors there. So how much are you going to be earning doing what you're doing, and how much are you going to charge for it? What's the likelihood of somebody suffering a real harm in connection with the services that you're providing? Again, with the selling dolls on eBay, probably pretty low. But on the other hand, if you're building homes, there's some potential for real harm there. Then what's the severity of the harm that could befall somebody? So if any of those, if the answer is basically high earnings, high potential for harm, great severity potentially, then all of those things point to setting up in such a way that you have some limited liability there. And so what is that? The idea with limited liability in this context is that you're running a business and the assets of the business are held in an entity which is separate from the owners of the entity. And so if you're able to keep that separation in place, if you respect that form, then what that means is if there is a creditor out there against you who gets a judgment, then they're going to be limited in their recovery to the assets of that entity. They won't be able to take your house or your personal bank account or anything like that. So the key to respecting that corporate form, really, or that separate form of the entity, is to really separate out the company from you individually. So you have separate accounts. There's a bank account for your business, and there's one for you personally as well. You have governing documents like an operating agreement, and you follow the terms of those governing documents. So for example, if there's a provision in your operating agreement that says you need the permission of all of the owners to borrow more than $5,000, then you need to make sure that you get that if you borrow more than $5,000. A big one is funding the entity with adequate capital. And so that really means on an ongoing basis that you're keeping enough money in there. First, you put enough in at the start of the business, but then as the business is running along, you're not taking so much out of the business that it's unable to pay its obligations as they come due. So for example, if there's a big debt coming due and you want to pull money out, but it would leave the company with no assets and no ability to pay that debt, well, if you pull that money out, then that's going to look like you're not respecting the separateness of the business, and that could put you at risk of a creditor being able to do what's called piercing the corporate veil, where they're actually able to look past the entity itself and reach your personal assets. So the other part of that is that the entity isn't an alter ego of yours. You're not buying your groceries with your business bank account. If you need to buy groceries with the money that's in the business, you take a distribution and then you get that in your own personal name, and then you buy your groceries with that. Anything that you're doing there that makes it look like the business is just set up for your own personal convenience, and you're not respecting that separation, is going to look pretty bad if a creditor comes knocking. And when all of those factors add up, it becomes a situation that a court might view it as you being the same as the entity itself, in which case there's no liability protection there. And the other thing to keep in mind with all of that is that limited liability is actually limited. So the best thing that you can do to help cover yourself as well is to maintain appropriate insurance that's going to protect you against any claims that happen. In addition to that, keep in mind that if you're performing services on behalf of the entity, then you are likely to also be sued in connection with something that goes wrong there. And so maintaining that insurance that protects the company for the acts or omissions of its service providers like employees and contractors is really important. And so as long as you do all of that stuff and respect that separate form, then it gives you a much better chance that when a court examines all of this, they're going to say at the end of it, this is a separate entity, you're going to be restricted. The creditor will be restricted to getting assets from the company, and your own personal stuff will be protected. So for most people, the easiest way to get that liability protection and set up a business is through an LLC, which is a limited liability company. And the reason that people start there is because it's extremely flexible, it's simple to create and operate, and it provides that liability protection that you're really looking for. So all you have to do to set it up is you go to the Secretary of State website, and when you go under business organizations, they have a place where you can file a form, and one of them that you can file is called Articles of Organization. And it's basically, it ends up being like a 2-page document that you file with the Secretary of State for a $50 fee. And once you've done that, then you've got your LLC set up. When you're in the process of doing that, just a couple of things to keep in mind. It's going to give you a choice of being manager managed or member managed. I always suggest that you have a manager as the manager instead of having the members, because if you have the members who can take those actions, it can create a great deal more ambiguity in terms of who actually has the right to act on behalf of the LLC. And I think that the easiest way to avoid that is with that manager designation. It kind of tracks with like a president or CEO designation for a corporation, which I think everybody's a lot more familiar with, but the concept is really pretty similar there. And so when you look at the LLC overall, I've got some cons on this page here, but they're basically all pros. The tax efficiency, you aren't creating an extra layer of taxation, and you also have the ability to choose from a number of tax structures within the LLC. So it's really nice from that perspective. It gives you the liability protection. And with everything that I just mentioned, and also the rules regarding ownership and when distributions can be made, it has a great deal of flexibility. So it's just a really nice structure, especially if you're starting out, because it can evolve and grow as your business does. I've got on the downsides there the cost, which is that $50 filing fee, and the need for an operating agreement, which I'll talk about more in a second. You know, those are downsides, but the burden is just really low there. So I think that they end up being worthwhile. If you're not in an arrangement where it makes sense to be a sole proprietor, then it's really not going to be a big leap to deal with the additional burdens that come along with setting up and running an LLC. The biggest burden there is probably going to be that you do have to respect that corporate form on an ongoing basis. And usually there are some questions or uncertainty at first when people start dealing with that. But as you familiarize yourself with it and get involved in it, then it's going to become pretty comfortable and second nature, I think. So with the LLC, whether there's just one owner or many, they're called members in an LLC, they should adopt an operating agreement, which is basically a contract between the member and the other members, or between the member and the company, on how the LLC is going to operate. And so it's going to set rules about who's going to put what into the company, when are distributions available, how are the taxes going to be handled. And if you don't have an operating agreement in place, then what that means is you're going to be governed by state law, which is going to be really painful. Just for starters, if you've ever seen an operating agreement or any long contract, then you probably know how much brain damage it can be just to try and look through it and keep paying attention, not fall asleep in the process. The operating agreement is going to be way easier than if you're reviewing the statutes that have been that are set up to govern the LLC. It's extremely difficult and confusing, and it runs you back and forth and all over the place. And especially when you get in with multiple owners, there are all kinds of unintended consequences there, because the rules of who has the authority to act and what they're actually able to do can really easily be overlooked there. And I've seen situations before where people get into all kinds of trouble or unexpected situations because one of the owners of an LLC decides to do something, and there's no operating agreement in place to restrict them from doing it. And all of a sudden, they've sold all of the assets of the company, and the other owners are just kind of up a creek. Even if you are just one owner, though, it makes sense to have an operating agreement in place. And so when I do these presentations in person, this is usually the point in which a bunch of hands go up and say, where can we get one? So the answer to that is that there are a number of sources. And in terms of the best place to get it, I'll start from the easiest and go to the most difficult. And the easiest is you can just Google it and you'll find an operating agreement. I guarantee you that using that is going to be a really bad idea, because if it has been vetted by anybody, it's going to be set up for someone else and not for you. So it's going to be a bad fit. If it hasn't been vetted, then it's probably been crowdsourced, and there's going to be all kinds of really crazy, ridiculous stuff in there. So don't just Google an operating agreement and use that. A better but still free alternative that you can use is the Pikes Peak Library District actually offers them to people who have a library card. And my understanding, I haven't looked at these, but my understanding is that they've actually been vetted by an attorney. And so what that means is it still might not be the right fit for you, but it's not going to have just crazy stuff in there. So I think it's a better starting place than if you're just doing a Google search. Next up in terms of cost would be like LegalZoom or something like that. You know, the real difference that I suspect you'll get between LegalZoom and the library is that with LegalZoom, they're going to fill the form in for you during the process that you're paying for there, but they're not going to really cater that agreement to you. So I think if that's your starting point, it's going to make sense still to just go to the library and start with one of the documents that they have there. You're going to be left to fill in some of that information, but it's going to save you a lot of money in the process. And then the last and most expensive is going to an attorney. And so when you go to an attorney, in most cases, I think they're probably going to end up charging you by the hour. Some will do it on a flat fee basis, but usually that's going to end up somewhere in the range of $500 for a single owner, very simple operating agreement, into the thousands when you're dealing with very complex operating agreements with multiple owners. And so a lot of people do start off, especially if it's just one owner, but even if there are multiple owners, they start off just using a form that they've cobbled together themselves, maybe using the library or something like that. But what usually happens is they reach a point of profitability or sophistication that it just makes sense for them to have somebody else who's been paying attention to what they've been doing there. And at that point is usually when I see people come in to have an attorney help them with getting that operating agreement set up. Now, from a tax perspective, that flexibility of the LLC gives you a lot of different options, all of which can be very, very efficient for you if you're worried about double layer of taxation or anything like that. The starting point for all of this, if you're a single member LLC or if you're a sole proprietor also, you're going to be taxed as a disregarded entity. And so what that means is for tax purposes, the entity actually doesn't exist. I'm not sure if you guys can see my mouse here, but basically starting at the bottom of that red line where the income is coming in on that chart, the income goes right past the LLC as if it doesn't exist. And so that's why it's disregarded. It goes right on to the income tax return for the owner of the LLC, and they're going to report it there. And so it means you don't have to even file any separate tax return for your business. The bad news is if you're doing, if you're providing services for this LLC that you own, then you're going to be hit with FICA taxes on that. And so that's going to include what's called the self-employment portion of that, which is usually paid by an employer if you're employed by a third party. Whoops. So if you're employed by a third party, then usually you're just going to see on your tax forms that 7.5% or so has been withheld on your behalf and or paid on your behalf. And so when you're a single member LLC, you have to pay all of that yourself. And that's a portion that is at least deductible, since normally the employer pays it. But it ends up, it's just a little bit more painful when you're dealing with that tax burden because you're seeing all of that come out of your own pocket. If there are multiple owners, then the default treatment for an LLC is a partnership. And so this is a tax partnership, which is a little bit different from the partnership I was talking about before, which is a state law entity structure. So when you have a partnership, starting on the chart where that income is coming in, it's no longer a disregarded entity. So what happens is once you get to the LLC, that income is going to be reported by the LLC on Form 1065. And what they're going to do is they're going to issue K-1s to each of the members in proportion to their ownership interest in the company. And then each of the owners is going to pay income tax on their allocated portion at their own individual income tax rates. And so what that means is even though you have this income tax return that's going on at the LLC level, it's a pass-through entity. So all of the income just passes through and is simply reported by the individuals on their own income tax returns. In addition to being taxed as a partnership, the LLC can also elect to be taxed as a corporation, C corporation, or an S corporation. So we'll talk about those tax structures later, but one of the nice things about the LLC is that it can graduate to those different treatments later on if it doesn't make sense to set up like that from day one, and you don't have to go and convert to a state law corporation, which is a much more complicated process.
Steve, this is Rita. We did have one question from Rosemarie. She's asking how to consider expenses that was made regarding my business before my LLC had been created.
So if you will be the only member of your LLC, then the expenses are going to be treated just the same. So, you know, that's all stuff that would be reported on your own income tax return, and you can take the deduction for the expenses right on there, same as if you hadn't had the LLC set up.
Great, thank you. Rose, if that answers your question, just let us know. Thank you.
And so with the next structure that I'm going to talk about is the corporation, which is really the classic. Calling it the classic always makes me think of a cheeseburger, but the sort of entities that I'm thinking of here are like Apple or Target, really large publicly traded companies, and they're all going to be corporations. And the reason they all choose that structure is because they're built for outside investors. They're built to be kind of standardized in terms of the rules that govern them. And that's also why you see a lot of them being formed under the laws of a few specific states. So Delaware, South Dakota are probably two of the most popular states for corporations to form. And a lot of the time, especially with publicly traded ones, but even with some private ones, you end up seeing that they formed in those states. Colorado, too, though, has good corporation laws, and plenty of our clients who are set up as corporations are just Colorado corporations. Sometimes they move to Delaware when they're being acquired or when they have a big investor coming on because they like those standardized laws. But otherwise, and often, you know, they can just continue their whole existence under Colorado law. And so the way that they're set up, instead of having that operating agreement in place, the first thing that you do is you file articles of incorporation with the Secretary of State. And those articles contain the rights of the shareholders and set the basic terms that are going to govern how the corporation makes distributions to its shareholders. It also defines what the business is going to be, what its purpose is, and it really sets the framework for the entire operation of the corporation. Then you have the bylaws, which are kind of a constitution for how the corporation will be run administratively. So it covers things like the election of directors and officers, appointments who are going to be running the corporation on a day-to-day basis. You can also have separate agreements among the shareholders, for example, to buy or sell stock upon the occurrence of certain events and things like that. Corporations can't be taxed as partnerships, but they can be taxed either as a C-Corp or as an S-Corp, as long as they comply with those rules. And just to drive it home, those are just tax elections. So sometimes you'll hear people say, well, I have an S corporation. And that's really important information, but it's also important to know, how are you actually set up? Are you set up as an LLC that's made an S election, or are you a corporation? And so anytime if you've made that kind of election, make sure you're telling people, I'm an S corporation that's organized as an LLC. That way your advisors, especially your CPAs and your attorneys, are going to know what you really have going on there, and that way they'll be able to provide you the best advice. So the good thing about the corporation is it's really all about getting a bunch of investors in there in most cases. So it can rely more heavily on the statutes, which means that you don't need an operating agreement. The problem with the operating agreement when you're bringing in outside investors is that it creates an opportunity for people to renegotiate terms that had been settled. That's really just not as big of an issue with a corporation because you're buying into the structure as it's already existed. The shares make ownership really easy to track, but at the same time, you have that benefit with LLCs as well. You can do, instead of tracking ownership of an LLC based on percentage, you can track it based on units, which equates to the same thing. And the reason that actually makes a difference is, especially when you have a new investor coming in, if you're say you've got 3 owners and they each own a third in an LLC, and then you've got a new owner coming in, suddenly if they're all equal, everybody's dropped down to 25%. Sometimes people get really upset because their ownership interest, they perceive it as being a reduction down to that 25%. Yet if everybody owned 100 units or 100 shares, you start with 3, so everybody's got that 1/3 interest, and then you issue 100 units to a new shareholder or member as well, everybody's down to 25%. But when you're tracking it based on those shares or units, people don't get upset about it. They're focused on the fact that they still have 100 shares instead of 1/3 of the company, they now own 25% of the company. So purely psychological, I think, but it does make a difference in how people respond to it. Also, in terms of outside investors, especially if you are in a business where you're looking for some sort of institutional investor, most of the time they're really going to want a corporation structure because it's easier for them, and also because they don't want to they don't want to be getting partnership tax returns or anything like that. They just want to make their investment, let the corporation continue operation, and see what happens with it. On the cons, there is a big one here, which is that tax structure. So we'll talk about that in a second, but the main one is the default structure as a C corporation is often frowned upon by small businesses in particular. It can cost more to operate because, unlike with an LLC, you know with a corporation that you've got a separate tax return. The administration of the corporation is a little bit more difficult, so often involves more legal advice when you're dealing with the various consents that may be required, or operating shareholder meetings or board meetings and that kind of thing, which also ties into the complexity of the management in general. You've got officers and directors who are running the show and responding to shareholders, so you've basically got 3 tiers of management and ownership with the corporation, whereas with an LLC, you really just have 2. You have a manager, and then you have the members. It also comes back to that structural rigidity. So you don't have the flexibility of moving things around as much with a corporation. Once you put stuff in there, it can be way more difficult to get it out, especially without significant tax consequences. So those are all reasons that that corporations are viewed more cautiously, even though they're still really popular, obviously nationally when you've got public companies, but also locally. Technology startups and even other types of businesses often do operate as corporations because they've figured out a way to make it work out well. So from a tax perspective, that default treatment that I was talking about is the C corporation. And you've probably heard people talk about double taxation before, and this is quintessential double taxation. And so the way that it works is you've got that income coming up into the C corporation, and there's this horizontal red line that goes through the C corporation, and that's the first layer of tax that occurs. So the corporation is going to be paying tax on all of its profits. Now it's going to be able to deduct the compensation that it's paid, including to its shareholders, but any profits that are left in the corporation at the end of the year are going to be taxed. And that's going to be before any dividends or distributions can be made to the shareholders. So then what happens if the corporation makes a dividend out to a shareholder is the shareholder is going to be taxed on that once again. And so that's where that double layer comes from. So it's inefficient from that perspective. But it can be really helpful because if the company is going to be operating at a loss, then that doesn't really matter too much. If you have investors who don't want to be getting a bunch of K1 information from a bunch of their investments, then they're going to like that. And there are also some benefits that are specific to C corporations that end up working out well for small businesses. So it's a structure that you don't want to jump into without really considering what are the implications of it, but it can make sense after you've evaluated and determined that you've got an economic benefit in setting up that way. The alternative structure for a corporation that is really, really popular is the S-Corp model. And the reason people like this is because it's a pass-through entity. And so you see a lot of professional practices, a lot of businesses of all types that are set up this way. And the way that it works is this green line that's coming out here over from the side, that's compensation that's paid to shareholders for their services. And so that's going to be subject to those FICA taxes. But since it's just tied to what's reasonable compensation, that means if you're doing a job, say your job is manager, people out in the community are paid $50,000 a year for it. Then all you have to do is pay yourself $50,000 a year for that, and you're going to pay the FICA on that. But then any other profits coming from the S corporation can be distributed out to you as basically end of year profits, and that's not going to be subject to that FICA tax. So you can end up saving significantly on the taxes in this structure. All you have to do is pay yourself that reasonable compensation. People often ask, what is reasonable? And like I mentioned just now, one of the keys is, what do people out in the community get paid for that? It depends on the industry. It depends on the market that you're in. My understanding is that CPAs actually have software that can help them determine what is reasonable compensation there. And sometimes you get different ideas from different owners. So there may be some people who are just more aggressive with it. They really want to drive down what they're paid as compensation because they want to take it as a distribution. The risk with that is if the IRS comes in and audits you, they might find that it's unreasonable. So that's just a hazard that kind of exists in connection with this. But if you have a really profitable company and you just want to make sure that you're getting as much as you can through distributions, then this is a really great structure that's going to minimize the tax hit that you pay on that. The downside with that is there are restrictions on ownership. So for example, you can't have more than one class of stock in an S corporation, but you can have voting and non-voting. You can also, you can basically, when you've got that voting and non-voting, it's a way of maintaining a degree of control over what's going on here. But if somebody owns 1% of the company, then they have to receive 1% of the distributions, and there's no way to get around that. So that's one of the reasons that sometimes people end up turning away from the S corporation and using, for example, a partnership structure there. A reminder again that the LLCs are able to elect S-Corp structure or C-Corp. The only thing to keep in mind with this is if you set up as an S corporation, make sure that your operating agreement provides for that. For example, if you go to the library to get your operating agreement, then it's probably going to have partnership tax provisions in there, and you want to get those taken out and replace them with much simpler language that relates to the S corporation distributions, just to make sure that it's consistent. This is one of those things that relates to respecting the form of the entity, and it's also something that the IRS would be paying attention to if they audited you.
Steve, let's read again. I have another question from Rose. It's regarding LLC. If she already set up an LLC with the Secretary of State, how can she verify if an agreement has been created? And if one hasn't, what can we do? What can they do?
So for better and for worse, you do not have to file an operating agreement or anything like that with the Secretary of State. And the reason that I like that is because those are private terms that are really meant just for the owners of the LLC to understand and to operate under. when you're filing articles of organization, when you're doing any filing with the Secretary of State, you don't have to disclose anything about ownership of the company itself. So my guess is that while sometimes people do file those operating agreements with the Secretary of State, my guess is always that they're not on file there, because generally they don't need to be, and there are some good reasons not to file them. If you're not sure if you have one in place right now, then my suggestion would be adopt a new one. Instead of just calling it the operating agreement, call it the amended and restated operating agreement. So basically what you're doing is you're replacing any that may have existed before. And you can even include a statement at the top that says the member or members were not certain if a prior operating agreement existed. If one does exist, it can't be located. And so they're adopting this one. And then that gets you back up and running with the agreement that you know what it says and it covers what you're looking for. So the other types of entities that I just like to touch on real quick, the reason that I don't want to spend too long on them is because they're more unique and less commonly used for the types of things that we're talking about today. One of them is nonprofits. So if you're setting up a business that has a charitable motive, then maybe it makes sense to be set up as a nonprofit. The only difference is there's no private benefit to the owner at the end of the day. If there are profits that are left in the nonprofit, then they stay with that organization to continue perpetuating its mission. The people who provide services to it, though, can still be compensated. And so it's a way that you can set up a business and do good in the process. And as long as you're complying with the additional requirements that are associated with the operation of a charity, then it can be a really effective way to run a business and also make a living. One of the reasons that it's less common here is people are really looking for businesses that they can set up and operate without those additional reporting obligations. And often the goal is just to maximize that profit without explicitly driving toward some sort of charitable purpose there. So that's why it ends up not being used as much, and for good reason. Another sort of hybrid is the public benefit corporation. And there are actually some big ones that exist like this. Like an example is the outerwear company Patagonia, where they donate a portion of their profits every year to nonprofits that are set up with environmental purposes in mind. And so basically what that means is all of the owners of Patagonia, it's a privately held company, so it's not publicly traded or anything like that. All of those owners are accepting a lower return on their investment in exchange for the good that they're doing. The reasons that I'm not crazy about them in general, Patagonia does everything right, so they're a great example of it. But a lot of companies form as public benefit basically to do what's called greenwashing. And so the reason it's called greenwashing is I think it initially started as a reference to what oil companies were doing. So they would be doing things without much concern for the environment, but then they would be advertising and sort of presenting themselves as doing all of these great environmental initiatives, which kind of disregarded the real purpose behind what they were doing, and there wasn't a lot of substance to how they were presenting themselves as environmental. The other problem with it is that there's not really any good accountability for these public benefit corporations. So there's not a lot of way for the public to truly see that these companies are doing what they're purporting to do by setting up for some public benefit purpose like that. And so then the last thing, getting away from those entity structures, are just some other items to consider that I like to cover in this. As you're operating your business, in my experience, these are some of the primary issues that come up that business owners are dealing with on a, if not day-to-day, then at least frequent basis. We talked about the changes in tax laws. Do subscribe to some of those mailing lists so that you can get that information. It's just a really good way to get an alert in front of you, and then you can do more digging if it's something that looks like it's going to affect you. Anytime you're moving an entity from one state to another, or setting up, or you've got an LLC that you want to switch to a corporation or vice versa, those are more complicated types of transactions to engage in. And so anytime you're doing that kind of thing, my first and foremost advice would be, that's a point where you do want to talk to an attorney about what you're doing. I've even seen very sophisticated businesses do this wrong in ways like, say you have an LLC that's set up and operating in Utah, and the company wants to move to Colorado. I've seen companies where they'll just come to Colorado and they'll form a new LLC under Colorado law and continue operating as if it's the same thing. The problem is that it's not. So what they've done at that point is they've created a Colorado LLC, but they've still got this Utah LLC over here. And which one is going to hold the assets in that situation? It's going to be the Utah one. So you've got all of the property that's still in the Utah LLC, and they haven't been merged. And so it can just create a lot of problems down the road. It's very simple for attorneys to help you with converting from one state to another, but it's a trap for the unwary if you just try doing it yourself. So it's good to get some advice before you do that. When you're changing entity form, then there are, just as I just described, there's a way to switch that actual entity from one type to another. But equally important is to understand the consequences of doing that. So it's not just the income tax rules that I was talking about earlier. It's also that if you are converting from an LLC to a corporation, then you're contributing the assets that are in the LLC into the corporation. Getting them out is going to be a lot harder than it was to put them in. And it's also going to be harder to get them out than it would if they were in an LLC. And so just reviewing the consequences of those things beforehand makes a lot of sense, and it can save a lot of economic heartburn after the fact. Rita, did you have something else?
We have a couple of questions here. Sorry, we got a couple. Let me scroll back up. Are dividend distributions executed once a year only? And this is from Rebecca. Or can multiple distributions throughout the year be done? And then she has a follow-up question to that. So
okay, and I just pulled up the chat window, so I've got that there. Thank you.
Yeah.
So dividends can be made basically whenever there's a surplus. The reason that you see it, or that I referred to it as being done at the end of the year, is because that's when it really makes sense to you from a tax perspective. In general, what I suggest to people is that they figure out, like if you're talking about a corporation, figure out a timing that makes sense. I think quarterly is probably a fairly regular one. Twice a year, once a year, all of those make sense. Just something that is kind of a prompt for you to do it. If you have an LLC, especially if it's single member, then it becomes a little bit more fluid. And so like my wife has her business set up as a single member LLC. And when she's accrued enough money in the bank account, then what she does is she makes a distribution to herself. So there's no rhyme or reason really when she's doing it. It's just when she knows that there's going to be enough left over there for the business to cover its upcoming debts, and she's got the revenue coming in, so it's going to keep on building. Then she'll go ahead and pay herself out. As long as you've got an arrangement where you're not going to be leaving the business without the assets to pay its debts, then you're going to be okay, whichever approach you take there. In terms of mailing lists, I don't really know of any good ones for small businesses. The ones that I use are really designed more for advisors, professionals, that kind of thing. I think there's one called the National Small Business Institute or something like that. And so I'm doing a search real quick for it. That might not be it. I can see if I can come up with some, and then I'll let Rita know so that she can circulate that. Then the next question is, do we still carry insurance for an LLC? And my answer to that is absolutely. So the insurance is a cost-effective way of just making sure that if anything goes wrong, that there is going to be something there that will provide you with some coverage. The reason I say it's cost-effective is because it's going to be a lot cheaper than either settling or litigating the lawsuit. And the reason that I also like it is because it's just a lot easier and there's less risk than if you have to fight over whether or not your LLC is a separate entity from you, or if it's just your alter ego. That's a really stressful place to be in, and you never want to end up there. So if it's something that can be resolved with a payout from an insurance company, then I think that's great. The reason that I wouldn't suggest relying entirely on insurance is, what if they deny the claim? What if you accidentally allow your policy to lapse? There are all kinds of things that could happen that, if they do, you want to make sure that there's still a barrier in place between that company and yourself individually. And so then the follow-on question, with an LLC, would you file your business taxes with your normal 1040? If you are the only owner of the LLC, then yes, it just goes on your 1040. And so like even with TurboTax, they've got a really nice and efficient way of doing it, where you basically just plug in all of your sources of income, all of your expenses, and it's going to report that typically on Schedule C of your 1040. Sometimes when it relates to real estate, it ends up going, I think, on Schedule E, but it's all going to be on your own individual tax return, and you don't have to worry about filing a separate one there. And definitely let me know if any other questions. Happy to answer them as they come up, but I'll just keep going through the rest of this slide. So the next item that I have on here is Nexus. And what Nexus means is, what's your business's relationship with other states? Are you doing business only in Colorado, or are you selling things to people who are located in Kansas and Nebraska? Do you have an employee who's located in one of those states and does work for you there? Anytime that you start forming those connections with another state, start thinking about whether or not you should be registering to do business there. What that usually ends up meaning when you register to do business, first you register the LLC with the Secretary of State in that website, or the corporation. Then you're probably going to need to be filing income tax returns for the business in those states. And so at that point, things get a little bit more complicated. You're not going to end up paying any additional tax because of that, but you are going to have some additional administrative burden that's associated with filing in those different states. The reason that you want to get ahead of that is, if you fail to introduce yourself in those states, and the state gets wind that you're doing business there, and somehow they always do, they always know who's doing business in their states, then they're going to send you a little questionnaire, and it's going to be really innocuous, and they're going to say, hi, how's it going? We just want to know what you're doing in our state. We heard you might be doing something there. And if you reply, then usually your answers are going to cause them to say that they have tax and other jurisdiction over you, and they're going to require you to get compliant with them. If you don't send the notice back, then you're going to get another one and they're going to get more aggressive. And ultimately, what they're probably going to do is assert some deficiency on tax. Sometimes it relates to employees who might be working there, like unemployment insurance. And then there are going to be interest and penalties that accrue on those. And so once you're in that position, you're basically trying to, you're in a defensive posture and you're trying to fight your way out of all of these additional expenses that have been built in there. The best way to handle that is to get in front of it. When you start doing business with those other states, just be on top of it and accept the additional expense that comes with that. And if it's not worth it doing business there to incur that additional expense, then don't do business there. It's going to be a lot easier to deal with it that way than the downside if they end up coming after you. References for insurance companies for small businesses. I'll have to think about that one. There are some brokers that we've used for businesses who are looking for different types of policies, like Six and Geving, and there are some smaller ones as well locally that provide insurance brokerage services. I can see if I can come up with any other ideas on those. If you can't come up with any ideas on insurance for your business, even starting like for your auto insurance broker or your renters or homeowners insurance can be a good place to start to get some information on who you might be able to turn to there. So the follow-on question is, if a husband and wife work a business together and file a joint tax return, should each individual be listed on Form 2553 to apply as an S-Corp? I love this one because it's really in the weeds. So the question there really lies in who are the shareholders of the corporation. So on the 2553 is a form that you file with the IRS to select taxation as an S corporation, and all of the shareholders should be listed on that. So if husband and wife are both shareholders, then they should be on it. If only one is, then only that one needs to be listed on the 2553. So sales and use tax. This is another one that especially relates to doing business in other states, but even here in Colorado, just be mindful that if you're providing sales of property that require collection of sales tax, make sure that you're collecting that and remitting that in the way that you should be. If you're doing substantial business with other states, then also start worrying about the rules in those states as well. If you sell one thing to somebody in Kansas, then I wouldn't worry too much about collecting and remitting the sales tax to them. But if you're doing $100,000 a year in business in Kansas, then you should probably be collecting and returning to them. And if you don't, then just like with that nexus that I was talking about above, that's something that can really flag you. When they get wind of you, they're going to be paying attention to that, and you're going to be paying interest and penalties on that. For the tax withholding, if your business has employees, then you are going to be required to withhold and to remit to the state and IRS those withholdings. When you withhold that money, you're acting in trust for the federal government or the state government. So what that means is that money doesn't belong to you, even though it might be sitting in an account that is technically under your control. So what I see with a lot of small businesses when they're struggling to get going is they properly withhold, and then they look at their books and they say, I'm going to go out of business if I turn over this withholding. So I'm going to use it to keep my business afloat and worry about the withholding later, and true up with the IRS later. That's IRS money. And so if you do that, they're going to find out about it. They're going to find out about it quickly. And when they do, anyone who had any sort of control over writing those checks is going to be potentially responsible individually. Whether you have an LLC or not, it doesn't matter. You're individually going to be responsible for all of those withholdings that you failed to pay over. And there's going to be interest and penalties on those as well. And so my answer to any small business that is facing that issue where they're worried they're going to go out of business if they don't use that withheld money, my answer is go out of business. Let your company fold. You can start over, and you will be in a much safer position for starting a new business and also personally than if you go ahead and use that money that's supposed to be going to the IRS. Because they can go after individuals, this is something that can, and I'm not exaggerating when I say this, I've seen it ruin lives where somebody doesn't pay over withholdings to the IRS. The company goes out of business after a few years anyway, and then the IRS starts pursuing them individually. And it's a really easy trap to fall into, and it's not worth it. You're all here because you're entrepreneurs, and so you can do that again, and it's going to be a lot easier than dealing with the IRS. On that same point, the employee versus contractor item there. So those classifications are determined under state and federal law. And you can call someone a contractor, but if they meet the requirements of being an employee, like if they only work for you, if they're under your control and supervision, and if you're paying them, for example, an hourly wage, there are all these different criteria. And if they meet the criteria of being an employee and you're classifying them as a contractor, then you're going to get into trouble with the state, and you're going to get in trouble with the IRS as well, potentially. And so it's much better not to go down that road. The consequences that exposes you to are just really significant. And so it's better right off the bat to just look at, how am I going to be using this person who's performing services? And if they're an employee, then just deal with that. I know that there are some additional expenses associated with that, but that's another one where you can just really put yourself at a disadvantage if you get lumping people into the wrong categories there. And I see that Rita and DeAndre both provided some good answers for the question on insurance in the chat there. So thank you for that. And then just the final things here. I've tried to go through the different choices from simple to complex without getting too much into the weeds, but maybe more than some of you would have liked. There's a structure and an arrangement that fits every situation. It's just a matter of finding it. And so especially when you're starting out, especially if you're the only owner, then the answers to those questions though are really easy. And as you get up and running or bring new owners in, then you can start working through some of those other things. The nice thing about kicking the can down the road on some of that stuff is you're already up and running, you know that you're profitable, and so, or that you're making money. And so it just makes it a much easier situation to deal with the costs of structuring. When you're choosing your form, I think really the main stuff that it comes down to consider, one, the objectives. So are you doing this part-time, full-time? Is this like a grand plan where you're going to be the next Amazon? Or is it just going to be a mom and pop business? And I think both are fine. It's just going to inform, what kind of structure makes the most sense for you. What is your business and what's the potential for the liability there? And who's going to be your client or your customer? If you have a service that's dealing in a particularly litigious area, then you're going to want to factor that in when you're deciding whether or not you need an LLC or something else. Think also about those burdens of compliance and also the consequences if something goes wrong. You can weigh out, I think, pretty easily whether it makes sense to go through the process of setting up an entity for the benefit that it can provide you. And then the bottom line with all of that is you're not in this alone. So you have, in this community, you have a number of pro bono organizations and individuals who will help you out. You also have ones that will do it for a small fee, and even the advisors who charge for their services just because that's their business. Most, if not all of them, will talk to you and help you along the way, even if you're not going to end up working with them right now, just because we like seeing the community grow. And it's a really good way of making sure that people aren't just going to be stepping in it along the way. So make sure you use all of these resources that are available to you all along the way. And you know, it's exciting. It can be a little bit scary and intimidating at first, but with all of this stuff, once you do get rolling with it, it all starts fitting together pretty nicely, I think. And so that's everything from me with the slides. Do you want me to stop sharing here?
Yes, and I'll go ahead and invite, while you do that, thank you so much for the presentation. I think we had one more question come through the chat.
The timing of the 2553. So the due date for the 2553 is, I think it's 65 days. I can't remember off the top of my head from the date of formation. You can also make that election at the start of every tax year. So if you look at the instructions for the 2553, it will give you input on that. If you missed the deadline for it, then the IRS in general looks for what they call reasonable cause for missing that deadline. For example, if you had an advisor who failed to timely make the submission, or if it's something that you know, there were some natural disaster or something like that that caused you to miss it, then that's the kind of thing that the IRS looks for in making that decision. If you're not sure about whether or not you have a good reason, then just give me a call and we can talk through what the options are there and how best to deal with potentially missing that election.
Great, thank you. Sorry, I have two screens, so I don't know where my chat goes. Let's see, we have one more question.
While you're looking at that, Rita, I'm gonna jump in.
Sure.
Stephen, so sitting through these classes, it's always fun when you have a CPA and an attorney in these. And what I found out is a lot of times a CPA will want to set up an LLC so that way a business can get a lot of tax write-offs. And a lot of attorneys like to set up corporations instead because then it helps with the penetration of their assets. How do you feel? What's your thought and take on that?
Yeah, that's a great question. I think so. Corporations, they've been around for so long. There's robust case law surrounding the liability protection that they provide. The limited liability companies are so much newer that I think that, especially at first, like I would say, maybe for the first 10 years or so that there were limited liability companies, there was a degree of trepidation about whether or not courts would respect the liability protection aspect of them. I'm very comfortable with the liability protection aspect that an LLC provides, as long as you follow those respecting the corporate form type of restrictions. I think that you know, there's this saying that bad facts make bad law. And so there's always a risk that if you're a corporation or if you're an LLC and you're doing something that's really egregious, if there is a creditor that's coming after you, then that might end up setting up a situation where the court might disregard the entity, whatever the structure, and they might just say, we're going to allow them to pierce the corporate veil and get to your personal assets. But in general, I don't have any qualms about choosing an LLC over a corporation for liability protection purposes. In particular, if you've got more than one owner, that's something that can also help to strengthen the argument that it is separate from the individual. I always qualify that by saying that's not a good enough reason to, add someone as an owner to your company. But that's another factor that they'll look to, and they'll view that as helpful to the cause.
Thank you. We have one question from Rosemarie. As an LLC without any employees, when do we have an obligation regarding IRS?
So if you set up an LLC and you're providing services to it, then you have the reporting obligation on your 1040 that's going to cover not only all of the profits from the LLC, but it's also going to address the FICA taxes that are going to be assessed against you. An owner of an LLC cannot technically also be an employee of the LLC. And there are kind of some wonky tax rules surrounding that. But the bottom line is, if you're providing services for the LLC, then you're going to get hit with the FICA taxes. If you're not, if this is just a completely passive thing, then you can probably avoid the FICA taxes. And so your reporting obligation to the IRS would just be put on your 1040 the fact that you've got this income coming from that LLC, and then that's going to be that.
Great, thank you. If anyone has any additional questions, if you want to unmute, you're more than welcome to unmute yourself and ask the question. If you have any questions that may come up, later this afternoon or even tomorrow, please send those to me, and I will pass them along to Steve, and we'll do our best to get those addressed for you. So are there any further questions at this time?
Yeah, I have a question.
Sure.
Yeah, that it kind of piggybacks off what we just talked about. So he was saying that if we, do an LLC and we're not only like the owner, but we're also like the employee, how does that work then?
So if you're providing services for the LLC, then the only real difference there is everything that you receive through the LLC, so all of the profits associated with it, will be subject to that FICA tax. So you're going to report it, assuming it's a single member LLC, you're going to report it on your 1040. You're going to calculate the FICA taxes, and that's just going to be a component of your tax liability there. If you weren't doing services for the LLC, then that could be a different answer. But the bottom line is, when you have that disregarded entity structure like that, basically you get placed on the hook not only for the FICA taxes that you would pay in connection with any employment, but also for the employer's side of those as well.
So would it make more sense to do something like, if I'm a house cleaner, would it make more sense to do like a sole proprietorship then instead? Or is that same?
It will be the same. Yeah. So I would say, for house cleaning, that's something where there is potentially some liability exposure there. You're going in and you're providing those services in people's homes. You have potentially employees who are doing the same thing. So that's something where I would say having the LLC set up is going to make sense, and probably also having that insurance in place to make sure that you've got coverage in case somebody gets hurt, or in case there's some claim for like damage to property or something like that.
Okay, thank you.
Okay, we have time for one more question, and we did receive a question from Deb in the chat. Steve, I'm sure you can see if an LLC was formed but hasn't done business yet, does a tax return have to be filed for the LLC?
The simple answer to that is no. So no tax returns are required until they meet an income threshold. And so if it's not operating, or even if it's done business, but then it's been shuttered, then if it's in connection with dissolving an LLC, you would want to file a final return. But if it just doesn't have enough income to need to report, then that's okay.
Okay. Great. This was very informative. A lot of information this early morning, afternoon. So thank you again for your time today, Steve. Thank you again to DeAndre Net Business Banking for sponsoring this webinar today. And thank you all for attending. There were some questions, as mentioned, about insurance, and in addition to insurance consultants, the SBDC does provide free consulting services, again, for your business in many areas through the life of your small business. So if you are new and have not yet registered with the SBDC to get those services, we do encourage you to visit our website to learn more about our resources and for more webinars at pikespeaksbdc.org. Thank you everyone again today for attending, and you will be receiving an email later this evening or tomorrow with a recording and the slides presentation from today. Have a great day. Bye-bye.
Thank you, guys.